LaShawn, this weekend, LSU had me biting my nails. And then Michael sent me a photo. Guess where he was?
At the game.
At the Cowboys game.
Oh, my goodness.
In his Cowboys gear.
Well, you know.
Cheering on the Cowboys.
Oh, man.
That was painful. That was almost as, and I don't know what's worse, having a blowout or having somebody put you on the edge of your seat. I don't know.
The blowout, most definitely.
Mm-hmm. I remember growing up, if the Cowboys, it doesn't matter how far they were behind, they could be in the fourth quarter. You always say, Roger Staubach is there, it's going to be all right. Until it says 00, you know you have a chance. But yeah, it was interesting. The LSU game in overtime, you know, I always wonder, am I jinxing them? Mm-hmm. So when it came to the play, you know, I was doing this. And then when I had the cheering on the screen, I'm like, yay! And all my neighbors were texting me, oh my gosh, the game, the game.
I'm glad they won.
Mm. Me too. We have the Razorbacks next, and that's always a trap game for us. So hopefully we do well. We shall see. All right. Do you know where you're?
Yes, I think he'll be back in a minute here.
Okay. All right. So for the people in the gallery, make sure your phones are off. What I can tell you from my time as an attorney arguing, there's nothing worse where you're like in the groove of your argument and somebody's cell phone goes off. So make sure your cell phones are completely off. Don't do the silent thing because sometimes people do silent and it's not really silent. The other thing, the state attorneys and the defense attorneys have a job to do. So whether you like their argument or not, there is not to be any outbursts about somebody's argument. There's not to be any how dare you or any gasping. Does everyone understand? And I say this based on my experience as a defense attorney, a prosecutor, and as a judge. So we're not going to have that. All right, we're going to go on the record. Court is calling 2022 CR 11724, State of Texas versus Jordan Robbins. Can I have parties announced for the record for the state?
Raymond Saldana.
Daniel Rosengard.
Defense?
John Pulley for the defense. Chris Choate for the defense.
And are you Mr. Robbins?
Yes, ma'am.
All right. So you all have received an updated copy of the charge of the court. Have both parties had a chance to review it? State?
Yes, Judge.
Defense?
Yes, Your Honor.
State, any objections?
No, Your Honor.
Defense, any objections?
We review our objection to the lesser included on count one. Again, the state did not have this sort of evidence that any contact was for the sexual gratification of any party. Apart from that, we have no other objections.
All right. Any response? State?
We just urged the same arguments that we urged earlier, Judge, and we also use as the authority Gravy State 298 Southwest Street D 664 Texas Criminal Appeal 2009.
All right. Thank you. All right. Defense, your motion is denied. All right. Each side, you'll have 20 minutes. Does anyone want a time announcement from the court?
For the state judge, can I have 2 minute and a half minute 2.5 minute warning?
2.5 minutes. Okay.
2.5 minutes.
Defense?
5 minutes would be nice, Judge.
5 minutes. All right. Are you all dividing in time, your time up?
Do you want to?
Yes, Judge, we are.
All right. So do you want a time announcement?
I'm all set. Thank you.
All right. Thank you. Are you all dividing your time up?
No, Judge.
Okay. All right, so each side you have 20 minutes. And we're just waiting for the jurors. Thank you. Oh, state, Do you need to set up any PowerPoint? Anybody needs a PowerPoint set up?
It would only be me, Judge, so I guess when I start, Danny would be the one setting it up.
Does
Well, I'm
anybody want to see if it actually works?
Yeah.
Sometimes it does not. All right, it works.
Perfect.
Yeah. Sure.
Okay.
Let's make sure we had a guy do one.
Oh, no, he gets that. No, the only thing he did was like a hiring. There's a coupon there.
All right, so Bashan, you know, everybody's doing their fundraisers for, what is the name of that organization? United Way. So, you know, I'm doing my diet thing, right?
Oh, tomorrow, Judge.
Guess what somebody's doing? Mangonadas. How are you going to do that to me?
Favorite.
It is. And I only just became aware of mangonadas, what, last year?
Last year.
Oh my gosh, they're so good. And then they go put it in the basement. It's so easy to get to.
You're not gonna let everyone know, huh?
Oh, you know what? I'm not going to do it. I'm going to be strong. It's going to be hard, but I'm going to be strong. And then, but Sean, where we come from, where it's $3, but they're saying they'll accept cash, Cash App, Venmo, and Apple Pay. but not a check. Do you remember, somebody was just telling me well, I did retail work before. Do you remember when people had the credit card and you had to swipe it in that big metal thing? Those were the days.
Find the top copy.
Yes.
Then there.
And then the carbon copy would get all on your hands. Those were the days. I miss those days. I'm just going to delete that email. Pretend like it never existed. So, Bashan, you think we're going to get light bulbs anytime this year?
I'm gonna say no.
We've been waiting on light bulbs for 3 years
I will be our year judge
for light bulbs.
all things, replaced and fixed. I mean, the gate was supposed to be fixed too.
I think they're just waiting for that gate to fall on somebody. That could be a Lifetime movie, The Gate, and it's about that gate. We shall see.
I'm here to tell you what I did this weekend.
What did you do this weekend? Tell me.
Yeah, because you're
I
gonna
was
read the
up on
instructions.
board.
Oh my gosh, please, please tell me my nephew is okay.
Your nephew is fine, your niece, not so much.
Did you do that on purpose with Journey?
I didn't, but stuff happens. Wait, the hair will go back, right?
It will. My little,
I'll have to show you a picture.
okay. She's not gonna have the confidence as she runs through the grass.
She's lighter on her feet, much faster.
Yeah, but when she goes to dog parks, we're gonna say, what happened? The other dogs, what happened?
Her brother does look at her quite weird.
And he's probably just bouncing around. But when I was growing up, who knew that grooming was gonna become a multi-billion dollar industry? I mean, you would just cut your own dog's hair and
Well, now we
shampoo
know
them in the
why.
backyard.
Now we know why we don't.
Ah. I was telling somebody, I can't believe, I loved Briscoe County Junior because that show was about the coming thing. I can't believe I didn't see pet sitting becoming a thing. What did people do before when they went traveling overseas? Did they just leave their dogs outside and say, good luck?
And we're pet sitting this weekend.
Oh, wow.
See how that goes.
You got insurance now too, you got health insurance.
Health insurance.
Yes. I'm like, wow. But one of my friends, they ended up traveling and they had to get, a boarding for their pets.
Yeah.
Cost almost as much as the trip.
Yeah,
I'm like,
you gotta take them in and get them all their shots and everything done before you go.
oh yeah.
Yeah.
And then they got to make sure that they behave well with other dogs. It's just amazing. Well, the deputy tells me we're awaiting one juror. And Bashan, oh my goodness, the Saints, the Saints, the Saints. I could be wrong. I don't think we're going to the playoffs this year.
I don't,
Okay.
use out in judge.
Oh yeah, you just basking in your Steelers glow.
Y'all talked about my feelings so bad last week.
Yeah, you lined them up. All right, I'm being told that all the jurors are here. And so we will bring them in. Correct, yes.
All right for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you what is called the charge of the court. It's the jury charge. You do not have to memorize it. You'll be given the original with you when you go back to deliberate. Charge of the court. Members of the jury, the defendant, Jordan Robbins, stands charged in count 1 of the indictment with the offense of aggravated sexual assault of a child alleged to have been committed on or about the 23rd day of August 2020 in Bexar County, Texas. The defendant, Jordan Robbins, stands charged in count 2 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 3rd day of October 2020 in Bexar County, Texas. The defendant, Jordan Robbins, stands charged in count 3 of the indictment with the offense of indecency with a child by sexual contact alleged to have been committed on or about the 23rd day of January 2021 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of aggravated sexual assault of a child if, regardless of whether the person knows the age of the child at the time of the offense, intentionally or knowingly causes the sexual organ of a child to contact the sexual organ of another person, including the actor, and the child victim is younger than 14 years of age. 2, our law provides that a person commits the offense of indecency with a child by sexual contact if, with a child younger than 17 years of age, whether the child is of the same or opposite sex, and regardless of whether the person knows the age of the child at the time of the offense, the person engages in sexual contact with the child or causes the child to engage in sexual contact. 3, sexual contact means any touching by a person, including touching through clothing of any part of the genitals of a child, if committed with the intent to arouse or gratify the sexual desire of any person, or any touching of any part of the body of a child, including touching through clothing with any part of the genitals of a person, if committed with the intent to arouse or gratify the sexual desire of any person. 4, child means a person younger than 17 years of age. 5, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstance exists. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 6, the phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. Our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. There is no limitation period for the offenses of aggravated sexual assault of a child and indecency with a child by sexual contact. The indictment in this case was filed on December 12, 2022. 7, count 1, aggravated sexual assault of a child. The court, having determined that the evidence is insufficient to support the jury's finding of guilt to the offense of aggravated sexual assault of a child as charged in count 1 in the indictment, has granted the defense's motion for a directed verdict and herein instructs you to find the defendant not guilty of the offense of aggravated sexual assault of a child as charged in count 1 of the indictment. A verdict form is provided for you. You are instructed to next consider whether the state has proven beyond a reasonable doubt whether the defendant is guilty of the lesser included offense of indecency with a child by sexual contact under count 1 and proceed to paragraph 8. 8, count 1, lesser included offense of indecency with a child by sexual contact. Now, if you find from the evidence beyond a reasonable doubt that on or about the 23rd day of August 2020 in Bexar County, Texas, the defendant, Jordan Robbins, did intentionally, unknowingly engage in sexual contact with Arabella Robbins, a female child younger than 17 years by causing Arabella Robbins to touch part of the genitals of Jordan Robbins with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the lesser included offense of indecency with a child by sexual contact under count 1 as is instructed in paragraph 8. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of indecency with a child by sexual contact under count 1. 9, count 2, indecency with a child by sexual contact. Now, if you find from the evidence beyond a reasonable doubt that on or about the 3rd day of October 2020 in Bexar County, Texas, the defendant, Jordan Robbins, did intentionally or knowingly engage in sexual contact with Arabella Robbins, a female child younger than 17 years, by touching part of the genitals of Arabella Robbins with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child by sexual contact as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2. 10, count 3, indecency with a child by sexual contact. Now, if you find from the evidence beyond a reasonable doubt that on or about the 23rd day of January 2021 in Bexar County, Texas, the defendant, Jordan Robbins, did intentionally or knowingly engage in sexual contact with Arabella Robbins, a female child younger than 17 years, by causing Arabella Robbins to touch part of the genitals of Jordan Robbins with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child by sexual contact as charged in count 3 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 3. In this case, if there is evidence presented of more than one alleged instance that could constitute an offense committed by the defendant, if any, you are instructed that your verdict on each count must be unanimous about which specific instance, if any, constituted the commission of the offense for purposes of each of the individual counts. You are to consider only that one act as alleged in the indictment by the state in deciding guilt or innocence on that particular count. Evidence of any other alleged acts of misconduct by the defendant against the complainant in this case is not to be considered unless you believe those acts, if any, were committed beyond a reasonable doubt. With regard to those other acts, if any, you are instructed that said evidence was admitted, if it was, only for the purpose of showing the state of mind of the defendant and the complainant and the previous and subsequent relationship between the defendant and the complainant, if it does, and for no other purpose. You're instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law, as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty on the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you prepared to proceed with your argument?
Judge.
All right, you may proceed.
It was the new house in the living room, on the couch. He had me on his lap. He rocked me back and forth 2 to 3 minutes. It was hard, and it hurt, and it was uncomfortable. When I got up, it was wet in his private part area, but it wasn't wet when I sat down before. Those were Arabella's words. You learned in the jury instruction that sexual conduct means with the intent to arouse or gratify the sexual desire of any person. Again, it was hard, and it hurt, and it was uncomfortable. I'm going to take a few minutes and just go over this jury packet, these jury instructions, which are your guidelines. This case was originally charged as an aggravated sexual assault of a child, which does require skin-to-skin contact. But we don't know what a child will testify to when they come on that stand. Remembering details, we don't know what they may remember. And again, this is something we talked about during jury selection, remembering these details. So while there was no evidence presented of skin-to-skin contact, there was overwhelming evidence of the lesser included charge of indecency by contact that happened in the old house with Arabella in the bedroom, the defendant hard, hugging her tight. When she got up, there was blood in her underwear, and she's never experienced that before. And again, you will see in the definition of sexual contact that it's any touching of any part of the body of a child, including touching through clothing. Count 1 was in the old house. Count 2 and 3 were in the new house. Remember count 2, remember the shower. She described the finger motion that the defendant used on her when he went inside the bathroom. He didn't wash her hair, didn't wash her legs or her armpits. He only washed her there. And remember what the mom came in and testified to as well. He used that same motion before her and Mr. Robbins used to have sex as foreplay. Once again, the intent to arouse or gratify sexual desire of any person. Count 3 was on the couch. We talked about this, where he was rocking her and then he was wet all in that area. And then she went to her room and he went to his. You heard, and you'll see here on page 4, the on or about. It's important to remember, it is all the on or about means is just before the presentment of the indictment. That's what this means. And barred by statute of limitations, which again does not apply to indecency of the child by contact. The last part I want to mention is this burden of proof, that this is not an impossible burden. In fact, this is a burden that is made every day throughout courthouses across America, in Texas, and in this very building. I can't give you the definition of beyond reasonable doubt. That is up for you all to decide. So again, we have the overwhelming evidence that Mr. Robbins engaged in this conduct with the intent to arouse or gratify the sexual desire of any person. And that could be him, it could be Arabella, it could be anyone. Your Honor, at this time, the stage is going to reserve remaining of time for rebuttals.
Defense.
Good morning, ladies and gentlemen. Before I begin, I would like to just thank each and every one of you for listening through this case. As we talked about at the very beginning, these types of cases are difficult to sit through, right? The allegations are horrible. Whether they're true or not, they're difficult to hear. And I saw on some of your faces the reaction when Arabella testified. Whether it's true or not, it was horrible to hear, right? Because we only got one or two things going on here, right? Either Arabella has been coached, has been led, has been lied to, has been convinced about something that happened by her mother. We know the history there. Or she's lying. From my perspective, either one of those is disgusting. And it's a sign of abuse. As you heard from Dr. Bernstein, it's a sign of parental alienation. For God's sake, she's calling him Frank now. You don't think that's alienating the child? So I also wanted to go over a little bit with you about the instructions. You'll notice one of the important things that the judge talked about earlier is that at the close of evidence, we moved and the judge granted our motion for a directed verdict on the aggravated sexual assault of a child case. What that means is at the end of the case, the evidence was completely insufficient to support that claim. So the judge has ordered you, and you'll see it on the verdict forms, that you must find him not guilty of that offense. Now, I want to be clear that that is not a comment about what you should do on the other counts. Each one of those other counts, you now have to take back and do your duty. Consider each one of those offenses and make a determination about whether or not the state has proved their case beyond a reasonable doubt. Sexual contact, it was talked about very briefly. What I want you to do is focus on the definition of sexual contact and what it means as far as the indecency charge is concerned. The state must prove beyond a reasonable doubt that there's touching through the clothing of any part of the body with the intent to arouse or gratify the sexual desire of any person. I would just submit to you at this point, before we get into the actual arguments, that there's absolutely no evidence whatsoever of the intent to gratify. You'll see it from the early outcry that Arabella talked about. You saw it from Officer McAllister, right? There was no evidence of any intent to gratify. Otherwise, that investigation would have taken off at that point, right? The other thing I want to talk to you about very briefly, we only have 20 minutes, so I'm going to go quick, is beyond a reasonable doubt. Although the state, and it's their job to try to argue to kind of minimize that burden as much as possible. Reality is that's the highest burden that we have when considering a criminal case. It's the same burden that the state has to prove before they execute somebody. So they may argue about possibilities and probabilities and passion, and the reality is they have to prove their case beyond a reasonable doubt. And again, I'd submit to you that they have utterly failed. And you know why. One of the other things in this instruction that I want you to look at is one of the things about the unanimous nature of the verdict. Every one of you must agree as to the guilt or not guilty nature of this offense, okay? So when you get back there and you start deliberating, remember this has to be unanimous. Sometimes we get notes after the fact asking what unanimous means. Does everyone have to agree? Everyone has to agree on the result. And everyone has to agree that the state's proved their case beyond a reasonable doubt, or you must return a not guilty verdict. Okay? We've gone through. You're not supposed to look at anything on YouTube, TikTok. I think all that's is clear. One of the instructions I think is important, because I know this is what these cases typically revolve around, is you're instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. Why is that important? Because that's all the state has in this case. That's all they have, right? There was no law enforcement investigation, none. We all ought to be afraid of that. We ought to be disgusted with that. Because what they're asking you to do is to find someone guilty based on the uncorroborated word of a child. Think about it. There's no evidence whatsoever that corroborates, that supports any part of her story. None. And why is that? That's because it didn't happen. You've heard lots of testimony going through this case about, oh, and I'm sure the state will try to point this out. Oh, we were doing great. We were co-parenting. It was all peaches and cream, right? You know that's not true. You saw Miss Reed on the stand. You saw her lie on the stand about her own history. You saw me have to approach her over and over and over again just to tell the truth to you guys. You also heard from Dr. Bernstein, didn't you? State's witness, who talked about what? Parental alienation. That's just fancy words for one parent talking bad about the other, trying to turn the kid against them, right? We have a young child who's had to suffer through a divorce, that's learning how to live in two different households, right? And we have one who keeps wanting to use the system to get her way. Now, I don't know why. I don't know if she just has some issues because of her brain injury. I don't know if it's because she's moved on. She's on her second, third marriage. She's got new kids. She's tired of this going back and forth business. She doesn't like the Robins. I don't know why she's doing it, but it's obvious that's what she did. And I want you to go back. You'll see that there's medical records. Oh, they're right here. These are the medical records for Arabella, and I would encourage you, when you go back, to take a look at them. They're not secured, so whoever is kind of assigned to digging through those, go back and look at those medical records. We're not trying to hide a thing. Read them. Go back in that 2020 period when Ms. Reed gins up the false allegations against Mr. Robbins and his family. You'll see there's at least half a dozen entries about mom calling saying this, mom calling saying that. And you may even say, Mr. Floyd, why are you talking about the doc? Why are you talking about the life vest? Why are you talking about Arabella being hungry and tired and dehydrated? Because that's what she said about the Robbins family, that they were neglecting that child back in 2020. And she said that after she had filed the motion to modify her parental rights, trying to get custody of her child. She wanted to get that kid, to get Arabella in with her fold, with her two other children. She didn't want them having contact with them anymore. It's simple. It's easy. You can see it. Go back through those medical records. That's why it was important to talk about all that, right? Because you saw from the pictures and you heard from our witnesses. And by the way, our witnesses didn't hem and haw when the prosecutor started asking them questions, did they? It was straight up, yes, sir, no, sir, this is why. Arabella couldn't remember anything. She testified to you that she couldn't remember the allegations from the old house. When I'm questioning her, she can't remember any of the details from the new house. She can't remember anything other than what's been showed to her about a story she's told before. And you saw it. And it's sad. I'm praying for that child. But that doesn't mean that Mr. Robbins is guilty of this heinous crime. You realize, we talked about this earlier, he's facing up to 20 years in prison and being, and wear the badge of a sex offender for the rest of his life if he's convicted of this offense. This is no joke. And what does the state do in response to that? What do you expect law enforcement to do? What do you expect? Do you expect for them to go out and investigate? So we heard in 2020, what happened? She files a suit to modify custody. She goes to the doctor, starts making up lies. You'll see them in the medical reports. And then CPS gets called in, right? You'll see this pattern again in 2020. It's not going her way because it's not true. CPS did a thorough investigation. You heard from everyone. They investigated, they talked to everybody. They talked to the Robbins, they talked to Ms. Obregon, they talked to Tammy Robbins. They interviewed everyone and determined that was a lie. And who was that lie coming from? Ms. Reed. Oh yeah, then everything goes back to, that she has to withdraw her motion and agree to just drop everything. Because it ain't gonna happen, right? Something's going on. I don't know what it is. I don't know what it is. You know what? It's not our burden, is it? I don't have to prove what her motivation is. I don't have to prove that. That's the state's burden to prove each and every element of this offense beyond a reasonable doubt. And they can't do it because they're relying on Ms. Reed at the end of the day. So you may come to me and say, in your mind, Mr. Floyd, why would that child, and I get it, why would that child go through all this? Why would that child keep repeating the same story over and over and over again? Well, you saw it. She's repeating the story because they gave her the story to repeat, right? She said that she couldn't remember any of this until they showed her video, and then she could all of a sudden remember those details and nothing else. She can't remember anything before, she can't remember anything after, but she can remember that. That's because they showed her this video of her previous story that she gave. By the way, which came after mom had already gone through the doctor and the lawyers and CPS and drove her to the forensic interview. You heard mommy, she was already in lawyer mode, ready to do this again. But this time it wasn't going to be for neglect, something they did, because you could prove that didn't happen. Let's make up something worse. What's the worst thing you can think of? And Mr. Robbins is sexually abusing his biological child. Shame. And this is why details matter, ladies and gentlemen. All we have is the story of mom and the story of Arabella. And the details just don't match. Go back to those medical records. It's in black and white there. Then you move into 2022, the same pattern occurs again. It's weird though this time because mom starts questioning this child when she comes home from this trip to the Hyatt, right, the resort. Why is she upset about that? Why is that triggering her? You saw when I asked her, why you ask her about the sleeping arrangements at his house when she comes back from that vacation, that overnight trip. Her eyes got big. She stared out and nothing to say about it. Because it didn't make any sense, right? Why are you asking your kid who just got back from a resort about the sleeping arrangements at Mr. Robbins' home? Just mom's got something ginning up. And again, I don't know if this is bad faith, if this is mental illness, I've got no idea. What I can show you is if you go back through these medical records around that time period in 2020, you're going to find out that she contacted that doctor a dozen times. Every time something new came up in this case, what's she doing? She's calling the doctor. She's calling the police. She's building this case because this time it's going to happen.
5 minutes.
Thank you, Judge. So I'd ask you to go back. These medical records are very important. They were compiled long before we got in here and started going through this litigation. All right. Look at the pictures, look at the videos. I want you to notice one thing. You saw Arabella, right? The weekend before, the last time you ever saw her. You saw her dancing around in the kitchen, singing. She looked healthy. She looked happy. She looked like a normal child. You saw her when she came in here. Something's not right. So go back through those medical records, read them thoroughly. There's a lot in there. It's going to take some time, but we really think this is important that you focus in and do your job and do it correctly so that when you walk out of here, you don't have to worry that you made the wrong decision. You don't have to read 20 years from now that you convicted the wrong man for the wrong crime because it's all based on a lie. All right. Remember, we talked about Ms. Bernstein a little bit before, but I think it's really important to kind of hit on this. Remember, she was brought in right when these allegations in 2020 happened, a couple months later. 2022. Yeah, 2022, after these allegations came out. And it's amazing, right? She gets a referral from the lawyers from Ms. Reed side of the case. She takes on this case. Mr. Robbins is paying for half of it, right? He also goes in there voluntarily on his own, without lawyers, without protection, knowing that he's been alleged to commit this horrible crime. Does that sound like someone who's got something to hide? He went in there at least on 3 sessions without a lawyer, voluntarily. What do you think he would have told the cops had they decided that they were going to investigate? Now, I really want to point this out. The evidence that was presented to you was pathetic. We've got 3 law enforcement officers, McAllister, Apgar, and Guerrero, who did zero, nothing, zilch, right? They did nothing. McAllister, I think, is the only one who kind of told the truth. Well, he's the only one, actually, it seems to have gone through a mental process, but he didn't see any evidence of a crime. The other two did nothing. There's a lot going on in the background about this Hillary Murphy. She's a detective. You didn't hear from her. Who knows why? There's no evidence that an investigation was done whatsoever. And that alone should prevent you from finding anyone guilty of a crime beyond a reasonable doubt. You can tell the state, you can complain to the police department, but you can't find Mr. Robbins guilty beyond a reasonable doubt because of the failure of law enforcement, because of all the lies that have been told. You just can't do it. That details matter, right? So go back and look at all the details. Bernstein also talked about this concept of parental alienation, which I thought was important. She was being honest. And what she described, right, as the symptoms or the signs are just what we're seeing here. Alienate the child. Talk bad about the other parent. Report him to the police, report him to CPS. Why? To poison the mind of the child. And I'd submit to you, that's exactly what you saw. And it's scary. Oh my God, we should all be concerned about that kind of behavior. And he's had to suffer through it for 4 years. What does he do after the first investigation? Lies told about him, lies told about his family. He puts it aside for the interest of the child and tries to work things out with Miss Reed. That's not good enough for her. She wants it all. I think it's interesting though. She's got a new family. There's a couple new kids come along. Arabella's got new siblings. You see it all the time in custody battles, right? It's just common sense.
Time.
You're on. Thank you, Your Honor. Ladies and gentlemen, I appreciate your time. I appreciate you listening to me. I'd submit to you that once you go back and look at all the evidence, you'll have no alternative but to find Mr. Jordan Robbins not guilty. Thank you.
It was uncomfortable. It was hard. And it hurt. Those are the words that Arabella used when she took the stand, and she just explained one instance that she suffered at the hands of this man when she was between the ages of 5 and 7 years old. At that age, a child must be filled with pure happiness, with innocence, with joy, not have concerns of behavioral signs such as nightmares or panic attacks, and definitely not episodes of self-harm. This is undeniably concerning. And throughout this trial, ladies and gentlemen, you heard from several witnesses. You heard from Alexandra, which is Arabella's mom. She explained to you the on and off relationship she had with the defendant. She talked to you about the marriage, the divorce, but most importantly, she talked about the co-parenting relationship. She also talked to you about the modification in 2020 based on some concerns that she had. And ultimately, the decision was to keep things the same after Alexandra and the defendant met together and they settled their differences. Between 2020 and 2022, there is no evidence that indicates that there was problems with the co-parenting. Yes, she disagreed. Yes, she had concerns with his parenting style, but it didn't raise the level of problems where you had to fight in court for it. It was still a co-parenting relationship. Now, she also testified about the days leading up to the outcry. She testified about what happened in February of 2022 and how Arabella gradually disclosed the details of the abuse. And what did she do? She reported everything. She reported it to the doctor. She reported it to the police. She took Arabella to Child Safe. She took Arabella to the Center for Miracles. She took Arabella to counseling. What's the problem with that? That's what a concerned and a protective parent does. She also testified about the meaning of the finger, right? The gesture that Arabella showed you and what that means and why that was so significant to her. Because When she was dating the defendant, that was his foreplay. That led to sex. There's your sexual intent. You also heard testimony from Officer McAllister. Officer McAllister corroborates Alexandra because she reported it to the police and he told you that he responded to make the report. Now, he did treat this as a call for service and not as an offense report. And after I asked him difficult questions using his own report, he realized, you know what, looking back, I could have asked more questions. I could have done a proper initial investigation. And he also testified that days after, Alexandria called him and said, hey, I have new information that Arabella just disclosed to me. I would like to report it. And he told her, go to the police station and make the report, which leads us to Apgar. Apgar met with Alexandria for that report because she followed McAllister's instructions. This wasn't her idea. This was McAllister who told you, go to the police station. Apgar created the offense report. You have the indecency contact and referred it over to investigations. She also testified that the address, the new house address, which is on the report, is in Bexar County. But most importantly, she testified, look, the detective, she's no longer with Certs PD. I mean, what? If we don't have the detective, let's just dismiss the case and not seek justice? No. You also you also heard testimony from Dr. Stafford, the pediatrician, right? Arabella's pediatrician, and she helped us understand the meaning of the medical records, mainly focusing on 2020 and 2022, because that's what's relevant in the case. And she told you, I made the report to CPS. This was not Alexandria. This was based on what Arabella told me, and I made the report. That's what a responsible doctor does. Then she testified about the behaviors that Arabella displayed, particularly the ones in 2022. She said they were extremely concerning. Coming from the doctor that knows her all her life. You also heard testimony from Kelly Bernstein, the counselor. And she has over 15 years of experience dealing with children who have been traumatized through experiences like sexual abuse. She told you, I met with Arabella. Mom was in the waiting area. It was Arabella. And her records corroborate what Arabella has been telling us. And you're going to see those records as part of your exhibits. You're going to see the records. These are the records from the doctor. It's going to be there. She discussed how she reported to CPS. Those are the records from Bernstein's. You're going to have more records, but I'm just highlighting the important parts. This is what Arabella tells her. She also talked about how children use shapes to describe private parts and how the signs and symptoms of anxiety and PTSD that Arabella had were extreme. You also heard testimony from Dr. Kasoon, the child abuse pediatric expert, and she talked about the non-acute examination, medical evaluation, where it's over 120 hours after the last incident. You're not going to find scientific evidence in these cases. And yes, the finding is normal, but 95% of the medical evaluations have normal findings. Normal findings neither rule out nor confirm sexual abuse. She also testified about the relationships with the alleged abusers. Yes, children, they have their world, the family is their world. And you can have both. You can have family members that can hurt them, but at the same time, they can do fun activities with them. Both things can't be happening at the same time. And she also testified, very important, she said, disclosure is a process, not a one-time event, which is relevant to this case because that's what happened with Arabella. You also heard testimony from Miriam Sandoval. She talked to you a little bit about the child safe interview and what that consists of. One-on-one, no outside influence, non-leading questions. It's just the child and the forensic interviewer. She also testified that the children are taught the difference, or they're instructed as to what the difference between the truth and a lie is. They give them examples so they understand those instructions early on before the interview begins. And then she also told you that the forensic interview that interviewed Arabella is no longer there. Officer Guerrero came in quickly because when Alexandra made the report to Universal Police, the address that was given, which is the address for the old house, falls under Universal City jurisdiction. That falls under Bexar County. That's why he came in here today. But most importantly, you heard testimony from Arabella herself. And she talked about 3 different instances, right? The old house, when she was on the bed, she was 5 years old, and that he was hugging her, and that she felt his private on her private, and it was hard, it hurt, and it was uncomfortable, to the point where when she went to the restroom to go pee, she found blood in her underwear. And I asked her, has that happened before? She said, no, this is the only time that has happened. She also talked to you about the shower incident in the new house where she's bathing. The defendant comes in, grabs the washcloth and starts washing her genital area with this motion, as if you're playing the piano. This is her words. This is a child trying to tell you what this means. She doesn't know what Alexandra knows. And she also talked to you about the living room incident where he calls her in, he sits on his lap, and she tells you, it was not wet when I sat down and it was wet when I got off, to the point where she has to go to the restroom to get toilet paper and clean herself. She said it happened a couple of times. She talked about everything actually happening multiple times. Arabella wanted to tell him to stop, but she was afraid. She was afraid that he was going to get mad. She told mom in February of 2022. We also heard testimony from the defendant, and he talked about the divorce. How did it end? Amicable. Those are his words. The co-parenting was well. Arabella was 2 years old when that happened. Yes, he talks about the modification in 2020. He says he non-suited it. That doesn't make sense. Alexandria was the one that brought the suit. You can't non-suit another person's suit. They came into an agreement. That's what happened. They talked out their differences and they continued co-parenting. He did concede that when he was in the old house and his parents moved in, they moved out when Arabella turned 4.5 years old. What does that tell you? That tells you that he lived by himself in that house. Every other weekend, maybe every now and then, his girlfriend would come in and stay. But there were moments where it was just him and Arabella, just like how she testified too. He also accuses his own daughter of lying. She lied to ChildSafe. She lied to Bernstein. She lied to you all. And I pointed it out. If Arabella was lying, don't you think she would have probably made this bigger? Penetration, oral sex? No, in fact, she told you a lot of things she doesn't remember. He also talked about the temporary restraining order hearing. They brought it up. This was in front of a judge beforehand. He testified. Alexandra testified. Bernstein testified. The judge heard the evidence, and what does the judge do? Mr. Robbins, you are to have no contact with Arabella. He could have given her contact once a week. He could have given him supervised visitations in a third-party place while somebody watches the interaction. No, nothing. Defense's main argument is that Alexandra is coaching her. She's the one that's manipulating everything, that she's lying and that she has a motive in this case. He can't explain what the motive is. He doesn't know why, but he just says that it's coaching. But think about it for just 1 second. From the age that she was 2 all the way until this came out, how is the co-parenting? It was good. If that was really her motive, if that was her agenda, this would have started since Arabella turned 2 years old, and then gone to 3, and then gone to 4, and then 5. But it doesn't. It mainly just takes place in 2020 when Arabella starts talking about these concerns, which mom believed her. And then in 2022, this is what the sexual abuse outcry came out. There are some issues with Alexandra not remembering dates, yes, but we also know she's been through an accident. And she even said herself, that may affect the ability for her to recall things. And Arabella, she doesn't remember things either. We're not hiding that. She told you, I don't remember. She's being honest with you. You know why? Because for the past 2 years, she's been trying to forget. She's trying not to remember. Who wants to remember these things? It's understandable for her not to remember certain things. We talked about this in memory, right? Sometimes we go back, we think of certain things, but not of everything. That doesn't mean it didn't happen. We talked about, my partner talked about the aggravated sexual assault, bringing it down to indecency contact. There wasn't any testimony that talked about skin to skin contact. We talked about memory. So the next step is, but there is definitely evidence of over the close contact. And that's why we're asking for the lesser, because we do believe that it happened.
2.5 minutes.
Thank you, Judge. During jury selection, we talked about where is sexual abuse most likely to occur? In a private place or in a secluded area? That's the nature of these cases. You're not gonna have witnesses. You're not gonna have scientific evidence. You're gonna have testimony. And guess what? Remember what we talked about jury selection? Testimony is evidence. And Arabella's testimony was corroborated by expert witnesses and medical records that we presented in this case. I also asked you, what does a child sex offender look like? But I didn't ask you, what does a sexually abused child look like? You heard testimony from a very brave 10-year-old girl. But when you think of that, Arabella was not 10 when this happened. She was 5, she was 6, and she was 7 years old. And I want you to remember and picture the things that have happened to her like that as a child. Arabella, at times it was hard for her to speak. It was hard for her to say what happened to her. But most importantly, it was hard for her to tell him to stop. Well, today, we're here to tell him it stops. We are here to hold him accountable. We're here to seek justice. Today, ladies and gentlemen, I'm here to ask you to send a powerful message to the community. A powerful message that sexual abuse disguised as acts of care are unacceptable. I ask that you hold them accountable, that you hold them responsible, and then you find them guilty, because that's the justice that Arabella deserves. Thank you.
All right, ladies and gentlemen, you've heard all of the evidence that you're going to hear in this case. If I can have parties step down. That's 2 jurors to remain back.
I got. Yeah.